All rise. The International Court of Justice is now in session. President Anaya and the Honorable Judges Adsett and Loewenstein presiding.
Please be seated.
The case before the court is the case concerning the Caliph Yag. The parties are applicant, the State of Iraq, versus respondent, the Republic of Rakab. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Applicants, proceed.
Mr. President, Your Excellencies, may it please the Court. I am Andrew Connery, and I appear on behalf of the applicant, the State of Iraq. I will speak for 22 minutes, arguing on issue 1, that Dorda's conduct is attributable to Rakab, and that Rakab has failed in its own obligations to prevent the harmful actions of Dorda. And on issue 2, that Rakab has breached its obligations concerning endangered species and the environment. My co-agent, Daniel Farenthold, will speak for 21 minutes, arguing on issue 3, that Rakab has breached its obligations concerning human rights, and on issue 4, that Rakab has exploited and appropriated the traditional knowledge of Iraq and must pay a portion of the profits derived from the sale of the drug Alvectra to Iraq. We are also joined by of counsel Alexandra Nasser, and we respectfully reserve 2 minutes for rebuttal. Your Excellencies, states such as Rakab may not seek to avoid liability for wrongful actions by privatizing state agencies, and they are also under an obligation to exercise due diligence to prevent the harmful actions of those former agencies. With respect to the question of attribution, we submit that Article 5 of the ILC draft articles for the responsibility of states for internationally wrongful acts provides a test for attributing the conduct of former state entities such as Dorda to states such as Rakab. This article reflects that when states exercise government authority and are empowered to do so, that conduct is properly attributable to the state. Here, Dorda's actions with respect to the manufacture and sale of pharmaceutical drugs and the necessary yak harvesting in order to accomplish this are attributable to Rakab. There are 4 factors that bear directly on this inquiry. First, Rakab created and empowered Dorda by privatizing it in 1996, as indicated in paragraph 10 of the compromise. Second, taking recourse to the history and traditions, which is the first port of call in an Article 5 inquiry, as indicated by comment 6, to Article 5.
Need we agree with you on each of these factors?
I'm sorry,
Need we agree with you on each of these factors in order to find that the act is attributable to the state?
With respect to the inquiry under Article 5, it is a totality of the circumstances inquiry that is consistent with what Judge Crawford of this court noted, writing in a scholarly capacity in 2013, and also consistent with what former Judge Ago of this court has written when he was the special rapporteur for the articles.
Counsel, you referred on a few occasions to the fact that this is a formerly state-owned enterprise. Why is that fact relevant?
First, Your Excellency, it is relevant because under an Article 5 inquiry, the history and traditions of the particular society in question, as opposed to states generally, is important for considering whether the conduct is attributable to the state. That is reflected in Article 5, and it was, for instance, the substance of the...
So why isn't the fact that the entity was privatized evidence of the fact that it is not, in fact, attributable to the state?
That is by default under international law the presumption. That we accept, and that is consistent with, for instance, the jurisprudence of this court in its Barcelona traction case. However, with specifically to the question of scientific research and the conduct of the state agency, the Department of Research that existed prior to 1996, there was one entity in Rakab that conducted research and produced pharmaceutical products and sought patents on those, the department. After the privatization in 1996, there is still one entity in Rakab that carries out any of those activities. It is not the case that simply because this activity has some commercial bearing, a factor the respondent may seek to rely on, that the conduct cannot be attributed to the state.
Isn't it an understatement to say it has some commercial bearing?
Not precisely, Your Excellency. Taking recourse, for instance, to the 2000 case of Mathesini v. Spain before the International Center for the Settlement of Investment Disputes, that tribunal considered that even acts in the commercial space could have either a primarily commercial or governmental nature, which it noted at paragraph.
Where's the governmental nature in this case?
It is governmental precisely because the conduct here was carried out by a state agency prior to 1996. And it was of essential importance, both to RCAB with respect to its pharmaceutical sector and to scientific development.
So, Agent, in order to cut this link between the government and the company, what would have had to have been done? Or is your view that it's not actually possible then for a state to privatize these types of functions?
It is possible to privatize these types of functions. In the present instance, not granting a statutorily enforced monopoly would have been one mechanism to do so. However, this continues to be the case, as noted.
What was the monopoly over?
The sale of prescription medicines within RCAB, Your Excellency.
And how is that relevant to the issue at hand in this case?
First, because Galvectra is a prescription medicine that is sold within RCAB. Second, the conduct necessary to produce that, the hunting of the caliph yak, we submit is attributable to RCAB as an incidental measure necessary to accomplish that. That is consistent, for instance, with the 1990 case of Foster v. British Gas, when although the state function that was considered, although the function there was the conduct of a former British agency dealing with natural gas, the attributable conduct were the employment practices of that company once it had been privatized. There, the most important factor was that the company, British Gas plc, had a monopoly over the sale of natural gas in the UK. There, the court found that factor sufficient, coupled with the fact that it had previously been a state agency, enough to attribute the conduct to the British state.
Agent, shifting gears a bit, why isn't your stronger argument that the state, why isn't the stronger argument that the state is directly responsible by its failure to exercise due diligence?
Certainly, Your Excellency, we do rely on that argument as well. With permission, Your Excellency, I will make one final point with respect to Article 5 and then directly address that. The final thing to note here is that a totality of the circumstances approach is warranted. Although we concede and acknowledge that conduct such as the minority share stake owned by the RCAB government, the continued subsidies and the regular meetings are not on their own sufficient to attribute conduct to the RCAB state here, coupled with the monopoly and coupled with the status of DORTA, we submit that the conduct could be attributable even if the monopoly and the former status were not enough on their own.
So if the state terminated the monopoly, would you lose?
It would make our position dramatically more difficult, yes, Your Excellency, but that is not the case in the proceedings before this court.
But why isn't a stronger argument that the state has direct responsibility?
We acknowledge that is our stronger argument, Your Excellency, and I will address it now. In our submission, states have a customary obligation not to allow activity within their territories to create reasonably foreseeable harm to the territory of other states. This is a principle that dates to the trail smelter arbitration and has been acknowledged by this court in its 1949 Corfu Channels case, its 1996 Nuclear Weapons Advisory opinion, and more recently in its 2010 Pulp Mills decision. Within the scope of this obligation...
But aren't the facts in the Corfu Channel case substantially different from those in this case?
We do acknowledge they are somewhat different. We merely cite to this case to acknowledge that there is a general principle with respect to customary international law that states may not allow territory or may not allow conduct in their territory that could reasonably...
Well, how far does that principle go? A general principle, extraterritorial responsibility seems quite broad if you're going to go beyond the facts of the Corfu Channel case.
Yeah. There are separate extents to which it applies with respect to due diligence and with respect to causation. With respect to due diligence, as this court acknowledged at paragraph 154 of its construction of a road case, when it comes to assessing the preliminary risk of matters, a lower burden is appropriate for the inquiry of whether harm is foreseeable. In that case, at paragraphs 154 and 161, the court considered the nature of the construction project in question. It was the increased scope of the construction of a road and the outsized impact it may have as it traveled through different wetlands and could potentially affect the San Juan River. Here, DORTA undertook a tenfold, or rather, RCAB allowed for a tenfold increase in the number of licenses issued to hunters within its territory, beginning in 2011 and increasing every subsequent year.
Counsel, in the construction of the road case, the relevant receiving area consisted of Ramsar sites that are protected in international law. Is there anything equivalent in this case?
Not directly equivalent, Your Excellency, but the Guar Highlands are the exclusive habitat of the Caliph yak, which is a migratory species only in RCAB and Eötvös. And I would also additionally note that as the court did there, the territory of the road was not exclusively Ramsar protected sites, but that was part of the territory in question. But in any case, the question of foreseeability was still the same here.
But in the facts before us, Agent, isn't it the case that, in fact, the applicant not only continues to hunt the yak, but actually hunts in numbers significantly higher than the respondent does?
It does, Your Excellency. However, as paragraphs 1 and 27 of the compromise indicate, the yak population has been stable for decades prior to RCAB hunting began, and there is no indication that the applicant's hunting is actually to blame for any of the harm that has happened. And in any case, at the latest, the conduct of the respondent could foreseeably contribute to damage in 2016 in June with the release of the ILSA report, which specifically noted that it was the nature of RCAB hunting, as opposed to necessarily the amount of RCAB hunting, that was what was to blame for the harm in question.
And you've noted this question of who is to blame. In the situation that we have before us, who bears the burden of proving to this court who's responsible?
With respect to questions of foreseeability, it is our burden as the applicant to demonstrate that the harm here was foreseeable and that the respondent has breached any particular obligations with respect to due diligence. Although we do assert in the second pleadings that there are different burdens of proof that may apply in a particular context, which I will address there.
Counsel, in the companion San Juan River case, we determined that a diversion of flow of 2% away from Costa Rica was not significant harm, and therefore no EIA was required. Why is the approximately 4% taking of the axe any different?
First, Your Excellency, with respect to the simple factual nature, as we acknowledge, at the latest, the foreseeable harm would be 2016, when it would be a continued taking of 4%, and one that contributed to a potential decline in the yak population of only 10% in only 2 years, as reflected at paragraphs 27 and 36 of the compromise. And that would be sufficient not only to be foreseeable, but also to indicate that the respondent breached its due diligence obligations, which concern here 3 particular elements. 1, conducting an environmental impact assessment. 2, cooperating in good faith. And 3, taking other measures of prevention. Particularly with respect to the environmental impact assessment, RCAB conducted no environmental impact assessment until October and November of 2017, which...
Agent, did AROC conduct an environmental impact assessment?
The compromise is silent on that particular question, but as hunting levels have been stable for many decades prior, there was no particular need to do so, whereas there was specifically with respect to RCAB hunting here.
But does that mean, Agent, then that your approach to due diligence is one that is essentially dependent upon consequences? In other words, is your suggestion to us that a due diligence requirement kicks in not as a matter of the conduct of the state, but having to look instead at what the effects of the action actually are?
We do agree that due diligence is an obligation of conduct, as reflected in Article 14 for the article.
Would you accept then that if there is an obligation of conduct, then it's not one that AROC has met in these circumstances, having not done its own environmental impact assessment?
We would not agree that we are in violation of any particular obligation of international law. With respect to the question of environmental impact assessments in particular, as is relevant to the respondent state, although we acknowledge that the Pulp Mills decision at paragraph 205 indicated the scope and precise content of impact assessments is left up to the determination of the state carrying that out, at the end of that paragraph, the court indicated that first, those impact assessments must occur preliminarily, something that did not occur here, and they must bear some relation to the risk carried. Here, the impact assessment the respondent carried out could not have begun later than October 28th of 2017, and it published its final results and the final regulation on November 15th of 2017. This time frame is far from sufficient and is not consistent with the standards of many states in the international community, such as Thailand, Australia, Canada, the European community generally, and Tanzania, as the obligations binding on Tanzania as reflected in the bituminous road
I believe
case.
that's the case with regard to environmental harms. What about with regard to the human rights claims?
In our submission, we would put forward that states are responsible for foreseeable impacts on human rights in particular. This is consistent, for instance, with the Maastricht principles and general principles of international law, drawing on either cases such as the Corfu Channel case, which was not limited particularly to environmental harm, and the same principles reflected in the other cases.
Are they the same extraterritorial obligations?
We do acknowledge that they may be different. With respect to the precise extraterritorial obligations of either of the twin covenants, my co-agent will address those more extensively. With respect to the substantive obligations contained in the second pleading, it is our submission that the respondent has violated the Convention on Migratory Species, and accordingly, yak hunting in its territory must cease. Here, there is an obligation under Article 3, Paragraph 5, to prohibit the takings of protected species, such as Appendix 1 species. Once the Caliph yak was included in this appendix in October of 2017, the respondent was under an obligation to prohibit its takings. In order to demonstrate that it has not breached this treaty, the respondent must demonstrate first that a valid exception applied, and second, that any takings pursuant to that exception did not operate to the disadvantage of the species. It bears the burden of proof with respect to both of these points, as this operates as an affirmative defense and would accordingly be in line with the jurisprudence of this court's predecessor in the 1924 Mavromatis decisions, as well as a number of other cases before this court. With respect to the question of exceptions, the respondent cannot invoke either the extraordinary circumstances exception or the scientific purpose exception. The extraordinary circumstances is meant to be one limited to exigent circumstances that connote a type of emergency or time-sensitive question, consistent with the plain meaning interpretation of its ordinary language, consistent.
Pardon me, but if a member of my family had diabetes and required life-saving medication, I might consider that an extraordinary circumstance. Would I be wrong to do so?
With respect to the particular legal term of art, extraordinary circumstances, it is our submission that that does not encompass particularly the production of the drug Alvectra. We acknowledge that public health is a reasonable national interest. However, with respect to this point, there are a number of alternative diabetes medications available, including those.
Are they as effective?
Generally, yes, Your Excellency. There are a number on the WHO model list of essential medicines, as Galvectra was, as noted at paragraph 37.
If they're so effective, why is there such demand for Galvectra?
It may be the case that it is a cheaper alternative. It may be the case that it is even marginally more effective, but that does not directly address the extraordinary circumstances exception, which, especially taking recourse to the object and purpose of the Convention on Migratory Species, which is a strict conservation objective, must be interpreted narrowly. The most prominent instance of this exception being invoked
Why shouldn't it be interpreted consistent with human rights obligations with respect to right to life and right to health?
It should be interpreted consistently with that, but as the twin covenants indicate, such rights can only be limited because when doing so is the only way to accomplish that type of interest.
And what's your support for that statement?
That is generally in line with the interpretive practice of the chief interpretive bodies of those covenants.
They use the word only way? I mean, that's not the language of those covenants, is it?
With respect to Article 18 in the ICCPR and the idea that any limitation must be necessary, that would be in line with those interpretations. But with respect specifically to the case of extraordinary circumstances, for which the interpretive jurisprudence with regard to the human rights treaties would not be directly applicable, the practice of states, such as Australia, when it comes to dealing specifically with shark attacks, was to invoke the taking and to invoke this exception with respect to great white shark takings.
In your view, if there were no other alternative medications available, would that then qualify as an extraordinary circumstance?
It may, depending on the precise necessity, the precise use of those medicines.
Used for diabetes.
If it were directly to save human lives, and it were a trade-off between saving human lives and the decline in the yak population, then in that case, it may be consistent, Your Excellency. But it would still be necessary to take into consideration the overall effect on the yak population. For instance, if it were to go extinct, then the medicine would no longer be available at all. And indeed, when states such as Australia and others have attempted to invoke this exception for such a non-necessary objective, such as simply preserving beach access, they've been condemned, for instance, by South Africa, as well as statements from Spain and Argentina, and, for instance, high-ranking officials charged with the implementation of CMS.
Is one of the issues here, though, Agent, the point that you had just made a second ago, which is this question of were to go extinct? In other words, are we not operating to a certain extent in a hypothetical situation where it's presumed that perhaps the yak may go extinct, but having to balance that as the court against the immediate threat to human life and the immediate consequences on human life? And in that case, oughtn't we to take a balance that puts more weight on preserving human life?
Not with respect to the risk of the yak going extinct, not within the context of CMS. The conduct of the respondent here has already violated that treaty and is ongoing and continues to violate that treaty. Although we acknowledge the importance of human life, there is no particular evidence the respondent can adduce to meet its burden of proof on this question that Galvectra is the only and necessary means of actually preserving life.
In your view, how many yaks could the respondent state harvest under either the extraordinary circumstances or scientific purposes exceptions?
Yeah. Extraordinary circumstances is best limited to emergency situations when someone's life is immediately threatened, and accordingly, it would be a case-by-case inquiry that should be generally limited. With respect to scientific purposes, there is not necessarily a particular number, but it must be the case that the takings are for the particular research in question. Here, the drug Galvectra had already been researched and discovered, and to the extent that any further takings were necessary to develop synthetic alternatives, as indicated at paragraph 33 of the compromise, it would not be necessary to take the 30,000 yak that the respondent did. It would likely not.
And my question was, how many could they take?
It is unclear based on the facts in the compromise, Your Excellency. If it were the case that this court...
But isn't your position that they can take none?
Strictly within the context of the Convention on Migratory Species. If this court were of the opinion that some takings were permissible in the convention, based on the Convention on Migratory Species, with respect to the question of remedy, that would simply indicate that a lower level of yak harvesting is appropriate, and accordingly, a partial remedy would still be appropriate for a roque. It is our submission, with respect to the case of remedy, that a complete cessation is warranted. That is, for instance, consistent with what this court did in its 2014 whaling case, when, although it may have been the case that some takings could have furthered scientific research of whaling on the part of Japan, the overall licensing scheme, JARPA 2 in that case, was still prohibited, and Japan was ordered to cease, as it noted at paragraphs 246 and 248 of its opinion. This is moreover in line with this court's predecessor's jurisprudence, such as that of the Torzau factory case. And accordingly, in order for the yak to rehabilitate and for the replacement rate of the species to rebound, it is necessary for this court to order either complete or partial cessation of harvesting. Thank you, and may it please the court.
Thank you, Agent. Agent, you may proceed.
Mr. President, Your Excellencies, may it please the Court. My name is Daniel Farenthold, and I appear on behalf of the applicant, the State of Eötvös. For the next 21 minutes, I will address the applicant's third and fourth pleadings. On the third, that Rekab's hunting of the Caliph yak violates the religious, cultural, and indigenous rights of the Orocan people. And on the fourth, that Rekab's manufacture and sale of Galvectra appropriates Orocan traditional knowledge for which the state of Eötvös must be compensated. Your Excellencies, Rekab's unsustainable hunting of the Caliph yak and its continued disregard for the effects this has on the human rights of the Orocan people violate numerous obligations which Rekab holds under international law. First, it violates the religious rights of the Orocan people, guaranteed under Article 18 of the International Covenant on Civil and Political Rights. Second, it violates their cultural rights, guaranteed under Article 15 of the International Covenant of Economic, Social, and Cultural Rights. Lastly, it violates their entitlement to protection of their traditional culture and spirituality under ILO Convention 169 concerning tribal and indigenous peoples. To turn first to the religious rights of your Excellencies, Article 18 of the ICCPR guarantees to the Orokan people their ability to manifest their religion. And under Article...
But this in Article 18, aren't the rights expressed therein subject to limitation?
They are, Your Excellency. As set out in Article 18.3, in some circumstances, the respondent would be permitted to limit the rights of the Orokan people to manifest their religion.
Agent, I don't want to interrupt while you're concluding that thought, but actually you have said the respondent would be responsible, but why the respondent? Isn't the state that is responsible for the rights of the Orokan people the state of Orok?
Not in all circumstances, Your Excellency. The argument here is that the respondent is under negative obligations established under both the ICCPR and the ICESCR to refrain from conduct which burdens the religious and cultural rights of the Orokan people. We recognize that the applicant itself would hold some positive obligations to ensure the rights of Orokan individuals within its own territory, at least as established under the ICCPR.
Counsel, I'd like to ask you a hypothetical. Posit that instead of 30,000 yaks being taken in Rakab for purposes of manufacturing Galfetra, instead there was a revival of traditional cultural practices in Rakab among Rakabi Pizau. And that as a result of that, 30,000 yaks were taken in Rakab pursuant to traditional cultural practices, with exactly the same impacts on migration to Arak. In your view, would Rakab be in violation of its obligations under the human rights instruments that you're relying upon?
Likely not, Your Excellency, provided that under the understanding that the Pibzau adherents in Rakab likely would be able to hunt the Caliph yak in a manner consistent with its long-term survivability. As indicated, for instance, in Comprehensive Paragraph 1, the traditional Pibzau methods of hunting have been able to exist for many decades and have not led to this decline in the species.
So if the answer is no, why can't Rakab cull 30,000 yaks for the purpose of promoting the right to health or the right to life?
In these circumstances, Your Excellency, it is the manner of hunting that Rakab currently engages in, which creates its obligations under the ICCPR and the ICESCR. It is the fact that it hunts in this manner which leads to the decline in the population and the inability of the Orokan individuals in the northernmost regions to access the Caliph yak, that they have violated their obligations. If the respondent were able to determine a method to hunt the Caliph yak, which did not lead to this decline, we would agree that it would not be in violation of the ICCPR or the ICESCR.
But Agent, you're referring to the hunting being carried out by Rakab, but in fact, it's a private company that's carrying out the hunting.
We do concede, Your Excellency, that in large part the obligations present here would be reliant on this court finding attribution or a violation of due diligence with regards to the first pleading that my co-agent addressed.
So in what circumstances, Agent, would a private company be responsible for human rights obligations that are held by a state in which that private company happens to reside with consequences in another state? Is there any case law that suggests that a private company could be held responsible at law for consequences in another state, that state, which is their home state, could be held legally accountable?
Not with regards to international law obligations specifically, Your Excellency. We would not hold that DORTA could be found in violation of these treaties, which we do recognize are binding on the respondent as a state itself.
Agent, I still want to understand better your view on the scope of the cultural and religious rights obligations. Imagine this scenario. The yak no longer migrate to Arak because of some reason having nothing to do with the actions of the Rahabi government or Dorta, such that the yak are only located in Rakab. Would there be a right of access to Rakabi territory under the human rights instruments you're relying upon for the Tizau in Arak to enter Rakabi territory to perform religious and cultural practices?
Likely not, Your Excellency. Our understanding would be that providing that ability to access would be a positive obligation, and we do not put forth that the respondent is under any positive obligations with regards to the Orokan people themselves. It is necessary to establish that it is the respondent's hunting of the Caliph yak which has led to the inability of the Orokan individuals to access the Caliph yak that has led to this violation of the Twin Covenants on Human Rights. The respondent may argue, Your Excellencies, that these covenants do not apply extraterritorially, but this would be an interpretation of the ICCPR and the ICESCR, which this court has rejected. First, in its 2004 Wall advisory opinion, specifically at paragraph 109, this court considered the intent of the drafters in drafting the ICCPR and noted that it was not the intent of those drafters to allow states to escape their obligations merely by acting in an extraterritorial context.
But wasn't that a unique circumstance in that the territory in question had been under prolonged military occupation?
It was,
That's very different than the situation here.
It certainly is, Your Excellency, and this court has only passed on the question in the context of such large-scale military occupations. But looking to the decisions of other international tribunals, demonstrate that the appropriate test here for the extraterritorial obligations under these treaties is that when a state has direct and foreseeable impact on the human rights of individuals regardless of their location.
Can you explain which other bodies you have in mind and which specific treaties then, and why that should be relevant to us?
Certainly, Your Excellency. It is important to note first that this interpretation relies on the language subject to their jurisdiction, which is present within Article 2.1 of the International Covenant on Civil and Political Rights. This language also exists in the American Declaration of Human Rights and on the European Covenant on Human Rights, and is the jurisprudence of these bodies which reflects a similar understanding.
Could you repeat again what you said was the provision in Article 2.1 subject? What is the jurisdictional clause in Article 2.1 of the ICCPR?
It is that states must ensure and respect the rights of individuals within their territory and subject to their jurisdiction.
So it has to meet both of those criteria then, in their territory as well as being subject to the jurisdiction. Would you agree with that?
No, Your Excellency. As this court identified at paragraph 109 of its Wall advisory opinion, this article could have been read conjunctively, but given the practice of the states parties to the treaty and the interpretive practices of the ICCPR and the Human Rights Committee, it would not be appropriate to adopt such an understanding, and there can be situations in which a state has obligations outside of its own territory.
What are the specific facts that gives rise to the obligation of the ICCPR or the other treaty?
Here is indicated at company paragraph 41, Your Excellencies. Individuals in the northernmost regions of Iraq have lost access to the Caliph Yak following two
But that's
seasons.
by virtue of the act of the corporation.
Yes, Your Excellency. Here, because the conduct of the corporation is attributable to the state of Rakab itself, as my co-agent addressed, its obligations would be...
Your co-agent referred us to you, addressing specifically the human rights responsibilities.
Yes, Your Excellency, and this would be consistent with understandings first set out, for instance, in the Maastricht Principles, which would recognize some situations in which states themselves incur obligations with regards to the conduct of businesses within their own jurisdiction. But similarly,
And why are the Maastricht Principles correct?
They are understood as a restatement of customary international law, Your Excellency, put forth by a group of experts on economic, social, and cultural
And
rights.
why are they understood as a restatement of customary international law?
They could be referred to, Your Excellencies, as an example of the writings of highly qualified publicists, consistent with Article 38(1)d of this court statute. Here they reflect an understanding that is consistent with the interpretation of many commentators with regards to the obligations, specifically the negative obligations which states hold, subject to the twin human rights covenants.
Have these been adopted by states, the Maastricht Principles, or are they an important academic exercise?
They have not been adopted as such by states, Your Excellency, although they are consistent with the understanding of some states, including, for example, Belgium and the Netherlands. Here is indicated at company paragraph 41, because the respondent engaged in this hunting via Dorda of the Caliph Yak, which has led to individuals in the northernmost regions of Iraq to lose access to the yak and leaving them unable to engage in their traditional religious practices and cultural practices, the respondent has violated Articles 18 of the ICCPR and 15 of the ICESCR. But even if Your Excellencies did not find that the human rights of the Orocan people were protected under either of these instruments, the Orocan people are still entitled to protection of their indigenous spirituality and culture, established under ILO Convention 169 concerning tribal and indigenous peoples, to which the respondent is a state party as indicated at paragraph 48 of the compromise.
Agent, I wonder if I could ask a hypothetical. If the situation of the Yak and the declining population had been caused by human activity that had led to climate change, for example, and as a consequence of that, the population was much smaller, would your argument be that states that had some responsibility for climate change therefore had committed human rights violations and therefore were responsible as a consequence?
Likely not, Your Excellency. Our understanding is that there would be some demonstration of causation required, that there would be a direct and foreseeable impact on the human rights of individuals, and we would not put forward an obligation incumbent on all states which have participated in global climate change.
Counsel, it seems like your strongest evidence of harm is that certain members of the Pizao in the northern part of Iraq have not been able to hunt yaks because the yaks are no longer reaching the far north of Iraq. But the yaks are still reaching more southerly parts of Iraq. Why is it an infringement upon the northerners' religious and cultural rights if the only impairment is that they have to travel a little bit to the south in order to conduct hunting activities?
In this case, Your Excellency, consistent with the understanding of the Human Rights Committee when interpreting the violations of religious manifestation rights specifically, any burden on the rights of any single individual would qualify as a violation of the ICCPR.
Any burden?
Yes, Your Excellency, so long it is not justified with regards to the permissible limitations on that right. For instance, in the case of Malachowski v. Belarus, the Human Rights Committee recognized that even rendering it more difficult for religious organizations to register specific addresses constituted a violation in that it burdened their ability to manifest their religion.
Agent, then, would any burden on the right to health also then be impermissible? So if it is actually more difficult to access diabetic-related drugs, is that then not also a violation of the right to health?
No, Your Excellency, at least not as would be interpreted by the Human Rights Committee, which this court has given great weight in referencing the obligations established under the ICCPR, for instance, in its Diallo decision of 2010. The interpretation of a burden on the religious practices is unique to the obligation of the manifestation of religion, given its practical and existent manifestations in terms of physical actions.
You mentioned ILO 169 on indigenous and tribal peoples. Like, who are the indigenous peoples here?
Specifically within the context of the ILO Convention, Your Excellency, the Orokan people themselves would qualify as indigenous under Article 11B of that treaty, which looks to several factors, including common descent from an ancestral population and continuous maintenance of the cultural and societal institutions of that people. Most important here, as indicated at Article 12 of the ILO Convention, is that the population self-identify as such. Here, the Orokan people themselves, as a national population, would qualify as indigenous under these factors, as indicated at Commentary paragraphs 3 through 7, 22, 41, and clarifications paragraph 1.
So you're talking about the whole of the Orokan people?
Yes, Your Excellency. We do concede that this factual situation of a majority indigenous population is somewhat rare, and there have been no international tribunals which have determined such examples. But there are cases which would qualify. For instance, the country of Eswatini, formerly Swaziland, is composed 85% of the Swazi population. In its 2014 communications to the Convention on Biological Diversity Conference of the Parties, the government of Swaziland itself referred to its Swazi population as indigenous, and they were similarly recognized as such in a 2015 concluding observation by the Human Rights Council. This would be one similar example, given the similarity in the populations between the two countries.
But don't most of the countries in Africa, even though the populations are in a literal sense indigenous, deny the applicability of the indigenous rubric to their countries?
Yes, Your Excellency, and in many cases that would be because the
But
population...
isn't that then the state practice, as opposed to just one instance?
It wouldn't necessarily speak to this situation specifically, Your Excellency, given that in many of those cases, those nations are composed of many disparate ethnic groups, which could together perhaps qualify as a majority indigenous population. But under the circumstances here, the Orokan people themselves do qualify as indigenous under customary international law and ILO Convention 169.
What customary international law?
With regards to the custom, Your Excellency, this would be looking to definitions of the indigenous populations put forth, for instance, by international tribunals or international commentators, such as Jose Martinez Cobo in his influential 1982 to 83 study on the problem of discrimination against indigenous populations.
If you haven't mentioned state practice, what state practice do you have for your proposition that this is customary international law?
In part, Your Excellency, the state practice would derive, for instance, from states parties to these treaties which accept the definitions included in these treaties. For instance, by signing on to the ILO Convention, many states have indicated that they support the definition of indigenous communities established under that treaty.
But Judge Anaya just mentioned state practice in Africa, which goes the other way. Why isn't the African state practice particularly probative on this issue?
To a certain extent, Your Excellency, the practice of many states signing on to the ILO Convention would be indicative of the existence of their own understanding of an indigenous population, and it would similarly be consistent with the main factor in determining an indigenous population, which is that of self-identification.
And to help with your argument, how widely ratified is the ILO Convention?
27 states have signed on to it, Your Excellency.
So out of the international community of 190-odd states, 27, does that meet the bar necessary to show customary international law?
Likely not on its own, Your Excellency, but given the nature of the states which have signed on to it, which would be, for instance, the vast majority of the states in South America, they could be understood as specially affected with regards to determining customary international law on the status of an indigenous peoples.
You mentioned the Martinez-Cobo report and the definition of indigenous peoples or populations included in that report. Isn't one of the factors non-dominance?
Yes, Your Excellency, and in the first instance we would note that the Orokan population was previously colonized, as indicated in Compromise Paragraph 6, by an external power. Similarly, it is the nature of the Orokan culture to be unique among the world, and is certainly the
But what about this factor of non-dominance? I mean, the Martinez-Cobo definition suggested it's current non-dominance, present time non-dominance.
Yes, Your Excellency, and in this circumstance, while they certainly would be the dominant power within Oroka itself as its national borders, it is not the dominant power within the Guar Highlands themselves. And some have put forward an understanding of this non-dominance on a regional matter. For instance, Erica Irene Deas in her working paper in 2014 on the concept of indigenous peoples, as UN Special Chairperson Rapporteur on the subject. In the interest of time, Your Excellencies, I will turn now to the fourth pleading, that Rakab's manufacture and sale of Galvectra appropriates Orokan traditional knowledge for which the state of Oroka must be compensated. The Convention on Biological Diversity and its 2010 Nagoya Protocol recognize the right holder status of an indigenous population to their traditional knowledge. And here specifically—
What's the traditional knowledge here?
The traditional knowledge here, Your Excellency, is an understanding by the Orokan population of the health benefits conferred by the Caliph yak gallbladder specifically, including its ability to prevent disease and recover from illnesses. It was this knowledge—
That seems very non-specific. Why is that sufficiently specific to qualify as traditional knowledge?
We would note first, Your Excellency, that it is an understanding, as indicated in Compromise Paragraph 16, of the gallbladder itself, which would give some degree of specificity to the understanding of the indigenous community. Moreover, given the definition put forward by the majority of states with regards to traditional knowledge, that it be a holistic scientific understanding passed down over many generations, it would not be appropriate to require specific understanding of the medical diseases or maladies which are cured by the use of these natural resources.
Agent, though, is there a difference between knowledge of a healthy diet or something that is useful for a healthy diet and something that has potential medical benefits?
There likely would be, Your Excellency, but given that the Orokan people here understood that the gallbladder would recover from illnesses, it would be our submission that this would go beyond an understanding merely of a healthy diet conferred by Tiringa Noslustuk, for instance. This would also be consistent with historical examples in which the knowledge of indigenous communities have been respected. For instance, in 2003, the University of
But
Montreal—
what if we find that this isn't, these aren't indigenous communities involved here? Does this whole line of argument fail?
Yes, Your Excellency. If Your Excellencies did not find that the Orokan people were indigenous, they would not be entitled to protection under the Convention on Biological Diversity or the Nagoya Protocol.
Well, well, okay, proceed. Yeah. There's some other language in the Nagoya Protocol, right? It's indigenous peoples and?
Local communities as well, Your Excellency. I apologize. If Your Excellencies did find that they were a local community, they would similarly be entitled to protection.
Can I ask Agent a question on timing? What point in time did, in your view, this become knowledge that was within the hands of an individual in Rakab?
At this point, Your Excellency, the knowledge was first appropriated in 2005 when the patent was granted on Galvectra. But the inquiry into whether access and benefit sharing, equitable benefit sharing obligations arise under the Nagoya Protocol can occur at many different stages. And in this case, it occurred at least in 2014, when the respondent continued to manufacture Galvectra and continued to utilize the same traditional knowledge of the Orokan people.
But did Rakab have obligations at the point at which the information was acquired under the Nagoya Protocol?
Not at the initial appropriation in 2005, Your Excellency, and we would not put forth any obligations at that period. But the respondent did carry new obligations whenever it converted this knowledge into the manufacture of a drug, first in 2011 and subsequently at least in 2014, when the Nagoya Protocol fully entered into effect.
But that knowledge was already within the hands of the individual concerned. Does that not require a retroactive application of the treaty in order to reach that conclusion?
It would not, Your Excellency. As indicated at Article 5.5 of the Nagoya Protocol, it speaks in terms of the utilization of traditional knowledge, which, consistent with Article 2 of the Protocol, would include circumstances in which the knowledge is converted to make its product for a specific use. This is similarly consistent, for instance, with the, I see my time has elapsed, Your Excellencies. May I briefly respond?
Yes, please.
This would also be consistent with African Union guidelines in 2014, which recognize that obligations under the Nagoya Protocol can arise at many stages of the use of traditional knowledge. Thank you, and may it please the Court.
Thank you, Agent. Now, we'll now hear from the agents of the respondent. Please proceed.
Mr. President, Your Excellencies, good afternoon, and may it please the Court. My name is Gabor Bajó, and it is an honor to appear before the International Court of Justice on behalf of the respondent, the Republic of Rakab. Alongside me is my co-agent, Zolta Buda, and Marcel Kanchik serves as bench counsel today. I will speak first for 21 minutes on Rakab's first and second submissions. My co-agent will speak for an additional 22 minutes on Rakab's third and fourth submissions, and we respectfully reserve 2 minutes for our third rebuttal. With your permission, I'm going to move on to our first submission, arguing that Rakab is not responsible for the alleged international wrongful acts addressed in the forthcoming submissions for 2 main reasons. Firstly, because Dorta's conduct is not attributable to Rakab under the law of state responsibility, and secondly, because Rakab fulfilled all its prevention obligations. Turning to attribution first, Your Excellencies, we do submit that states must be held responsible for international wrongful acts or omissions which are attributable to them. However, by invoking Article 5 of the Articles on State Responsibility, our well-learned colleague blurred the well-established line between the conduct of a state and the autonomous conduct of a private corporation. We do accept, Your Excellencies, that for attribution under Article 5, 2 conjunctive requirements must be fulfilled. Firstly, the entity must be empowered to exercise governmental authority.
Agent, you referred to the autonomous conduct of the corporation, but I noticed something quite peculiar in the compromis, which referred to the fact that when the Orocan Minister of Intellectual Property wrote to his Rakabi counterpart didn't respond. Instead, the response came from Dorta. So, in light of that fact, are you able to sustain the position that Dorta is acting autonomously?
Indeed, Your Excellencies, and this is clear from paragraph 11 of the compromis, according to which Dorta's board of directors is completely autonomous, and because the decision-making body of the legal person is in fact autonomous, according to international law, that private and legal person cannot be under state's control. And under Article 5, Your Excellencies, this honorable court should examine the specific acts in question for which the applicant seeks attribution and whether those specific acts entailed any governmental authority. And we submit that it did not for several reasons. Firstly, Your Excellencies, the applicant referred to Rakab's history and traditions, and we do accept that, according to the commentaries to the Articles on State Responsibility, this honorable court can examine a state's history and traditions to acquire whether a particular conduct is governmental in nature or not. However, Your Excellencies, we submit that, as a matter of fact, there is no indication in the compromis that the commercial distribution of Galvectra has ever been a Rakabi governmental function. We do accept, Your Excellencies, that research and development activities regarding healthcare.
What legal significance should we give to the fact that Dorta frequently meets with the Rakabi government to discuss national priorities?
Your Excellency, no further conclusions can be drawn from that fact, as only national priorities is too vague to confer any kind of control.
Well, isn't it an established fact that a national priority of Rakab is to promote its pharmaceutical industry?
Indeed, Your Excellencies, and we do not seek to belittle the fact that it is in fact a Rakabi commercial purpose to promote the right to health and, for example, Dorta's such activities. However, under Article 5, Your Excellencies, such test is not a subjective one, but an objective, as we do not disregard the fact that the purpose of distributing prescription medication in any case is in fact to serve the public.
As part of our judicial findings of fact and law, are we entitled to draw inferences from circumstantial evidence?
Indeed, Your Excellency, as this Honorable Court stated at page 18 in the Corfu Channel case, if the applicant does not have any direct evidence, it can rely on circumstantial evidence and inferences of fact. However, this Honorable Court also stated in that very same paragraph that it can only do so if that accusation proves applicant submissions beyond a reasonable doubt, which is a really high standard of proof, Your Excellencies, which is not met in this particular instance. And such accusations that former government officials and executives of legal persons met on a regular basis was already addressed, for example, by the tribunal in Methanex v. Canada, where the applicant stated that the mere fact that the former governor of California, Governor Gray Davis, regularly met with executives of pharmaceutical and chemical corporations, ipso facto meant that there was some collusion between them. And even though the tribunal tried to rely on inferences of fact and connect the dots per se, it could not lead to any conclusion. The tribunal said at least that the mere existence of those meetings cannot lead to the conclusion that there was some collusion between the parties. And this is exactly what we put forward, Your Excellencies. And secondly, we also submit that the particular activity for which applicant seeks attribution is in fact fully commercial and therefore not attributable under Article 5 of the Articles on State Responsibility. As it is clear from the commentaries, Your Excellencies, that fully commercial conduct is not attributable under Article 5, which was confirmed in the jurisprudence of international tribunals, for example, in Bosch versus Ukraine. And the applicant argued extensively that, for example, in Foster v. British Gas, the European Court stated that because of the mere fact that British Gas had a monopoly on certain activities.
What makes this pure commercial conduct? Aren't there some public policy factors very much at play here?
Indeed, Mr. President. However, we submit that the public service purpose of a certain conduct never means that it is attributable under Article 5, which was explicitly and repeatedly applied in the jurisprudence of international tribunals, for example, in Intertrade v. Czech Republic or Jean de Noul v. Egypt, because it is in fact the nature of the conduct which is relevant under Article 5 and not the purpose, according to the tribunal in CSOB v. Slovak Republic. And the nature of that particular conduct will always remain fully commercial if it secured commercial benefits to the entity and it was conducted with legitimate commercial considerations, according to the tribunal in Bosch v. Ukraine and Bayinder v. Pakistan. And Your Excellencies, looking at the 3.2 billion euros generated from Galvectra alone, according to paragraph 38 of the compromise, it is undeniable that Dorta sold Galvectra not only in Rocob but in 85 different countries in order to make a profit and not to serve any of Rocob's alleged policy agenda. And therefore we submit that that particular conduct is in fact fully commercial and thus not attributable for the sake of Article 5 of the Articles on State Responsibility. And just going back to the applicant's argument, Your Excellencies, in Foster v. British Gas, because in fact in that particular state the European Court did say that monopolistic services were actually or had to actually abide by the European Union's directive. In that particular case the question was not attribution under general international law. The question in that case was whether a private person can seek remedy in front of a domestic court vis-à-vis another private person for a state's failure to enact EU directives into domestic law, and therefore that particular case does not support the applicant's argument. For all these reasons, Your Excellencies, we submit that Rocob cannot be directly held responsible for Dorta's actions under international law.
Could Dorta be could Rocob be indirectly held responsible for Dorta's actions? In other words, are we constrained only to look at Article 5, or can we look beyond at other principles?
Indeed, Your Excellency, Rocob could potentially be held responsible for its failure to prevent Dorta from committing internationally wrongful acts. However, it is our submission that Rocob fulfilled all its preventative obligations for the following reasons. Your Excellencies, we do accept that under international environmental law, states do have a customary obligation to ensure that activities under their jurisdiction do not cause significant transboundary harm to the environment.
But there's a human rights claim here as well. You'll get to that as well, I assume? The responsibility of states with regard to human rights violations of private parties?
Indeed, Your Excellency. We submit that, in general, states do have a positive obligation to ensure that legal persons do not violate human rights. However, it is our submission that such obligation is essentially and primarily territorial, and this is going to be expanded upon by my co-agent under our third submission. And Your Excellencies, going back to Rakab's environmental obligations, it is our submission that the harvesting of the yak within Rakab did not cause any significant transboundary harm to Arok's environment, and even if it did, Your Excellencies, we submit that Rakab exercised due diligence in preventing such harm, and therefore it discharged its obligation.
Agent, on which facts do you draw the conclusion that there was no significant environmental harm? Isn't the evidence before this court, in fact, that the yak population is declining precipitously and in a very short period of time? How is that not significant environmental harm?
Your Excellency, allow me to answer your question twofold. Firstly, it is our primary submission that even if this court were to find that the decline in the yak population is in fact considered significant transboundary harm, that significant transboundary harm cannot be attributed to the Rokabi government or Dorta's yak hunting. And secondly, Your Excellencies, we submit that lacking any evidence on the baseline number of the yak population and the maximum allowable limits of decline in the yak population, it cannot be argued for sure that such a decline is considered significant. Indeed, Your Excellency.
In the case, Agent, though, if I could take you to a specific case of Trail Smelter, that's a case where it was a private company that was responsible for transboundary pollution, and in the end, the state, in that case Canada, was found responsible. Is that not exactly the kind of situation that we have before us today?
Indeed, Your Excellency, Rakab could in fact be held responsible for causing such transboundary harm. However, even in the Trail Smelter arbitration, firstly, Your Excellencies, the tribunal did not call for full cessation of the project, and secondly, Your Excellencies, it is also true that in the Trail Smelter case, the tribunal only accepted the applicant's arguments after it carried out, and I quote, the most thorough study ever made, end of quote, on atmospheric pollution. And in this regard, Your Excellencies, it is our submission that ILSA's report carried out in 2016 does not meet the standard of proof applied by this honorable court.
In the context of due diligence, the key question is risk. When did the risk of transboundary harm become apparent?
According to our submissions, that the exact time is found at paragraph 43 of the compromise when the yak was included in Appendix 1 of the Convention.
And why wasn't it
Migratory
earlier?
Species.
I mean, there have been plenty of reports that there had been a precipitous decline in yak population before its inclusion on the list.
Indeed, Your Excellency, the only causal evidence the applicant has put against us is ILSA's 2016.
So the question isn't causal evidence, the question is risk.
Indeed, Your Excellency, allow me to clarify. It is our submission that a state is under no obligation to carry out an environmental impact assessment as long as it carried out a preliminary assessment which showed that there is no risk of causing significant...
And what was the preliminary assessment?
Your Excellency, the preliminary assessment is found at paragraph 33 of the compromise, and it is expert evidence. And according to CBD's Conference of the Parties, Resolution 8-28, an expert evidence suffices as a preliminary assessment.
And was that independent expert evidence or evidence of your own government experts?
Your Excellency, that was expert from Dorta's scientists and experts. However, it is our submission that in that regard, the burden of proof would lie on the applicant to prove that such evidence was in fact impartial.
Shouldn't we give that less weight, though? Isn't that self-serving evidence if it's come from your own experts?
Your Excellency, in this regard, we would refer this honorable court to the genocide case judgment, where it stated that paragraph 227, that the probative value of reports will hinge upon, for example, their impartiality and the process through which they have been generated. However, in that particular case, the burden of proof also lied on the applicant to prove that such evidence was in fact not impartial. And in this regard, Your Excellencies, we would put forward that Dorta's experts are in fact not partisan, and in that regard, we submit that the preliminary assessment was sufficient to discharge Rakab's obligation not to carry out
What
an EIA.
indication is there? What is there to show that their experts were in fact impartial? I know you understand that it's the other side's burden of proof to show that the impartiality, but you must be able to say something about how we're supposed to assess this impartiality.
Indeed, Mr. President, and in this regard, would refer this honorable court to paragraph 31 of the compromise, according to which when in fact Rakab's and Arok's Prime Minister met an interstate consultation, Dorta's CEO was also present, and she stated that she is very mindful of the population of the yak, Your Excellencies, and therefore it is our submission that Dorta is just as much invested in the preservation of the yak population as Arok's government is. And therefore, we submit that the expert evidence put forward by Dorta's experts are in fact not partial in this regard. And
I would like to ask you about due diligence obligations under the current licensing regime, which I understand gives a license to Dorta, capping at 30,000 yaks per year. But then Dorta hires individual hunters, but those individual hunters, it appears, are not subject to any particular constraints. So why is the obligation of due diligence discharged in these circumstances where the individual hunters collectively could easily exceed 30,000 yaks per year?
Your Excellency, in this regard, would refer on the compromised facts according to which Dorta's hunters never exceeded the number of 30,000 in this regard, and whether or not they were subjected to any other limitations, would submit that 30,000 is still 30,000, and therefore Dorta's hunters did not exceed that number. And additionally, Your Excellencies, under customary international law, states have an obligation to exercise due diligence, for example, to consult and to notify the potential affected states, as well as, in fact, carry out an environmental impact assessment. We do see that the obligation to carry out an EIA was not always considered to be an important part of states' due diligence obligations. However, in this regard, we subscribe to the separate opinions of Judge Jawara and Judge Donahue to the San Juan River cases, according to which the state cannot effectively exercise due diligence without carrying out a timely and valid environmental impact assessment. And as this honorable court, stated at paragraph 112 in the San Juan River cases, a state can discharge all its due diligence obligation through the process of carrying out an environmental impact assessment. And according to paragraph 7 of the clarifications of the case, Your Excellencies, ROCOB consulted and notified Arok's government authorities, government officials, and ILSA's representatives, and in this regard, we submit that ROCOB, in fact, exercised due diligence in preventing significant transboundary harm. Additionally, Your Excellencies, we also submit that ROCOB fulfilled its obligations under the Convention on Migratory Species by authorizing the yak harvest. We accept that the yak is in fact included in Appendix 1 of the CMS, and therefore range states like ROCOB can only authorize its taking if the taking itself meets the exhaustive list of exceptions under Article 3.5 of the CMS. In this regard, we would rely on the exception provision which authorizes hunting for scientific purposes for the following reasons. The applicant argued extensively, Your Excellencies, that such authorization can only be given for scientific research purposes. However, this is not the case. It is in fact true that this honorable court stated in the whaling case that in that particular case, such authorization could only be given for scientific research purposes. However, Your Excellencies, it is only the ICRW, the convention addressed in the whaling case, which authorized hunting exclusively for scientific...
In your view, would the exceptions under the CMS entitle ROCOB to harvest more than 30,000 yaks, or is 30,000 the cap? And if more, how many more?
Your Excellency, in this regard, would refer Your Excellency's attention to Article 3.5 of the CMS, where it is stated that in the taking of Appendix 1 listed species cannot operate to the disadvantage of the species, and therefore it is our submission that ROCOB can hunt as many yak as many will not operate to the disadvantage of the species.
But how do we determine how many that is? Can you give us any guidance?
The Article 3.5 does not give any guidance, Your Excellencies. However, ROCOB is in fact mindful, and therefore, according to paragraph 44 and 45 of the compromise, ROCOB continuously monitors Dorta's yak harvest every 3 years, and therefore, if the yak harvest will become unsustainable, ROCOB is going to see that and stop yak harvesting immediately.
To what extent should matters of precaution play into this analysis?
Your Excellency, in this regard, we would submit that the precautionary principle can in fact be utilized to interpret states' environmental obligations. However, we would put forward that the precautionary principle cannot be applied as a self-standing obligation, and in this regard, we would also submit that states' obligation and states' right to hunt Appendix 1 listed species lies primarily under Article 3.5 of the CMS, which makes no mention of...
So you're saying the precautionary principle doesn't apply at all?
Certainly not, Mr. President. We submit that the precautionary principle can be in fact be applied to interpret states' obligation under the CMS. However, in this regard, the CMS makes mention of states' obligation that the hunting cannot operate to the disadvantage of the species, and therefore we submit that states can in fact apply the precautionary principle to continuously monitor the hunting.
Agent, though, if the evidence of the rapid decline in the population of the yak is not evidence of disadvantage to the species, what would be?
Your Excellency, a rapid decline in the population of the yak could in fact be evidenced and be concluded that the hunting operated to the disadvantage of the species. However, we submit that such decline cannot be attributed to Dorta, as Your Excellencies, no baseline numbers are stated from the yak population when Dorta started to hunt the yak. In fact, Your Excellencies, the latest figures come from the early 2000s, according to paragraph 1 of the compromise, when Dorta started to hunt the yak in 2011, and therefore, Your Excellencies, it is perfectly possible that the number of the yak population has already started to decline before 2011, when Dorta started to hunt them. Additionally, Your Excellencies, we submit that the manufacture of drugs can in fact be sufficed for scientific purposes for the following reasons. We put forward, Your Excellencies, that this Honorable Court should examine legal instruments which have used identical wording to the Convention on Migratory Species.
You're relying on two exceptions under CMS Article 3.5, but that provision by its terms requires that the takings be limited in scope. Here, RCAB is allowing takings to take place anywhere throughout the entire territory of RCAB. Why are you entitled to rely on the exception in light of those circumstances?
In this regard, Your Excellencies, we would refer this Honorable Court to the subsequent state practice of states which authorize hunting of Appendix 1 listed species for example, scientific purposes. And for example, Your Excellencies, Brazil, Belgium, Albania, Georgia, Chile, and Italy also authorize hunting of Appendix 1 listed species for scientific purposes without restricting the scope of the taking to a smaller territorial scope.
Well, perhaps those states are in violation of CMS.
Your Excellency, could I answer your question?
Go ahead, briefly.
Your Excellency, we would submit that no states, no CMS state parties have stated that such states would be in violation of the CMS, and therefore we would submit that they are not. Your Excellencies, thank you for your kind attention, and may it please the Court.
Thank you, Agent. Agent, you may proceed.
Thank you, Mr. President, Your Excellencies, and may it please the Court. My name is Eötvös, and as an agent for the respondent state, I will spend the following 22 minutes addressing the remaining two submissions concerning RCAB's human rights obligations and the alleged misappropriation of Uruk traditional knowledge. Turning directly to the first of those issues, Your Excellencies, I will argue that RCAB did not violate the cultural and religious rights of the Uruk people, and in support of this claim, 2 points will be formulated before this Court. Firstly, we submit that RCAB's human rights obligations, including its obligations of prevention, do not apply in an extraterritorial manner. Secondly, and in any case, Your Excellencies, I am going to show this Court that any limitations that might have been imposed upon the Arakan people's human rights were permissible under international law. With respect to our first argument, Your Excellencies, we do not deny that under international human rights law, a state's responsibility might be engaged for actions that produce effects outside the state's territory. However, this happens only if the state in question exercises jurisdiction outside its own territory, as made clear by this Court in paragraph 109 to 112 of its Rule Advisory Opinion and in paragraph 216 of its Armed Activities Decision. Your Excellencies, this requirement is clearly reflected in Article 2.1 of the ICCPR as well, which defines the Covenant's application specifically on the basis of jurisdiction. Therefore, what we put forward here is that Under both covenants, the essential question before this court should be whether the people of Iraq are subjected to Rakab's jurisdiction. And Your Excellencies,
If Rakab's military had set up a machine gun in Rakab territory, pointed into Iraq, and started shooting people in Iraq, under your view of jurisdiction, would Rakab not be responsible for human rights violations?
Your Excellency,
Killing particularly under Article 6?
Your Excellency, in that specific case and with respect to the right to life, we submit that Rakab could be held responsible, and in this respect we could refer this court to the European Court's judgment from 2009 in Andreu v. Turkey, when indeed a very similar case had occurred, and in that particular case the European Court held that shooting from close range across borders is such a direct and immediate impact and so overwhelming that it could render the individual victim of those human rights violations under the jurisdiction.
So are you suggesting that the territorial scope of obligations under the human rights treaties are dependent upon the specific substantive obligation?
Certainly not, Your Excellencies. However, what we submit is that only a direct and extremely immediate impact could be sufficient to establish jurisdiction under human rights law. Your Excellencies, in this respect, the applicant indeed formulated an argument, and in their view, a foreseeable direct impact could be sufficient to establish in itself human rights jurisdiction.
But aren't some of the reviews expressed by the Human Rights Committee, other treaty bodies, and regional institutions like the American Court of Human Rights, don't they show a trend that's more expansive, toward a more expansive view of jurisdiction than what you're expressing?
Your Excellencies, we do see that indeed there is a trend, for example, in the terms of the interpretative bodies of these covenants. We could refer this court to General Comment 24 handed down by the CSCR, and indeed the Inter-American Court of Human Rights also handed down an advisory opinion in 2017, according to which if an activity takes place on the territory of one state and causes potential harmful impacts on the territory of another state, that in itself could establish human rights jurisdiction. However, Your Excellencies, we respectfully request this court not to attribute great significance to those opinions. As Your Excellencies, such a basis of jurisdiction is not just manifestly unfounded in the practice of states, but in fact, it has been explicitly and consistently rejected by international tribunals, such as at paragraph 75 of Benkovic or paragraph 64 of Medvedev v. France. Therefore, Your Excellencies,
How is your argument consistent with the object and purpose of the treaties?
Your Excellencies, the object and purpose of the treaties is certainly to ensure the fullest realization of all human rights to all human beings. However, Your Excellencies, we would request this court to take into account indeed the subsequent state practice of states pursuant to Article 31, paragraph 1 of the Vienna Convention on the Law of the Treaties. And Your Excellencies, it is our submission that based on the subsequent practice of the 169 parties to the ICSCR and the 172 parties to the ICCPR, such a reinterpretation of the jurisdictional clauses of those covenants is not sufficiently established by the applicant. Therefore, Your Excellencies, it is our submission that those two covenants do not apply in an extraterritorial manner. And further, we also submit that the other convention relied upon by the applicant, which is ILO Convention 169 concerning indigenous and tribal peoples, also do not confer extraterritorial obligations upon the state of Rakab. And Your Excellencies, we submit that that specific convention was designed to operate in a domestic context.
Even if this court was to accept your views on the extraterritorial application of the instruments or limits thereto, is it not the case that there are adherents to the Pivsau culture and religion in Rakab who have been affected? And did they not, in fact, bring complaints to that effect?
Your Excellency, indeed, there are approximately 200 Pivsau adherents on the territory of Rakab. However, they have not formulated any complaints with respect to the fullest enjoyment of their human rights. Therefore, Your Excellencies, we submit that no territorial violation of those human rights could have occurred. Now, Your Excellencies, circling back to our argument concerning ILO Convention 169, we submit that the domestic nature of that convention...
Could I back up just a little bit? Now, if we were to not agree with you on the extraterritorial issue and find that these human rights obligations did apply extraterritorially, Would you concede then that there have been violations of the two human rights treaties that you mentioned?
Certainly not, Your Excellencies. If this court were to find that these covenants relied upon by the applicant do apply extraterritorially, we would formulate two arguments before this court. Firstly, is the argument that ROCOB has exercised due diligence with respect to daughter's conduct and with respect to the prevention of extraterritorial human rights violations committed by daughter. In this respect, Your Excellencies, we refer this court to the fact that ROCOB has consulted with OROC on numerous occasions, as evidenced by paragraphs 31 and 42 of the compromise and paragraph 7 of the clarifications. It is also significant that we have developed the Act Tracker application and we have conducted a comprehensive environmental impact assessment, which also entailed consultations with OROC and government officials and ROCOB EPSO adherents. Therefore, Your Excellencies, it is our submission that ROCOB has taken the necessary steps in order to ensure that no human rights violations occurred.
Are there heightened EIA or due diligence obligations when the affected population is an indigenous people?
Excuse me, Your Excellency, could you please rephrase your question?
Are there heightened due diligence or EIA obligations in circumstances where the affected population is indigenous?
Your Excellencies, in our submission, it is not inconceivable to think that in cases where the enjoyment of human rights and the protection of the environment are so much intertwined, as in the present case, indeed a greater care from the state's part is required. However, it is precisely our submission that, as evidenced by clarifications paragraph 9, ROCOB has been mindful with respect both to the environment of the Araucans and also to the enjoyment of their human rights.
But in addition to whatever perhaps requirements there might be under due diligence, is there not a requirement for enhanced consultations in the context of consultations with Indigenous peoples, particularly under the Declaration of the Rights of Indigenous Peoples?
Your Excellencies, indeed, we submit that if a state wants to fully discharge its obligation of human rights due diligence, consultations should be carried out with the indigenous community itself. However, Your Excellencies, we would emphasize that in the present case, the majority of the Araucan population, the overwhelming majority of the Araucan population is considered to be indigenous, and we do not dispute their indigenous status. Therefore, Your Excellencies, the fact that ROCOB has consulted with the Araucans themselves and the Araucan government officials is sufficient to discharge ROCOB's consultation obligation.
So you concede that the majority population of Iraq has indigenous status?
Your
And is
Excellency,
protected by ILO Convention 169 and the customary international norms that are developing with regard to indigenous peoples. You concede that indigenous status?
Your Excellencies, while we note that according to many international commentators and many international tribunals, for example, we could refer this court to the Ogiek case, a non-dominant criterion is a sine qua non for the characterization of indigenous peoples, we submit that under the present circumstances, there is no need to dispute the indigenous status of the Araucan peoples, as in any case, Your Excellencies, no violation of their human rights could have occurred, because, Your Excellencies, what we put forward here is that the production of co-vector...
No, I understand that, but I'm just trying to clarify your position. You are conceding that ILO Convention 169 applies here, that there are indigenous peoples who have been affected.
Your Excellencies, we submit that, yes, materially speaking, the Araucans do fall within ILO Convention 169's scope. However,
given that indigenous peoples often straddle international boundaries, wouldn't it be an odd interpretation to interpret ILO 169 strictly territorially?
Your Excellencies, in our submission, no, and in this respect, we would refer this court to the fact that indeed all provisions envisaged by ILO Convention 169 refer to domestic issues, with the exception of Article 32, entitled Contacts and Cooperation Across Borders. However, Your Excellencies, that specific provision has no bearing on the present case. Now, Your Excellencies...
Does that, though, Agent, not actually have to be read in context, and in particular looking at the particular, perhaps looking at the Declaration of the Rights of Indigenous Peoples as well, particular relationship between Indigenous peoples and land and resources? In other words, to pick up on my colleague's comment, to look beyond a strict territorial reading and to look at the broader context and the larger issues that are at play.
Your Excellencies, in this respect, our submission is that, for example, the United Nations Declaration of the Rights of Indigenous Peoples is not aimed at actually creating special human rights for the indigenous peoples, but is in fact could be considered as an interpretative tool of already existing human rights obligations.
Then why does it exist?
Your Excellency,
There's a declaration on the rights of indigenous peoples, so doesn't it create special protections, at least, for indigenous peoples?
Your Excellencies, in this respect, it is our submission that the declaration's provisions should be read together with already existing obligations, for example, under the ICCPR and the ICSCR. And it is precisely...
But if that's the case, then the declaration doesn't add anything.
Your Excellencies, we submit that it does broaden the scope of protection for indigenous peoples, especially with respect to cultural and religious rights, as it recognizes, for example, their intimate connection with the environment of the indigenous with the indigenous community. However, Your Excellencies, even if this court were to find that these covenants and the ILO Convention applies, we submit that the hunting initiated by Dorta is nonetheless fully justified, as it is indispensable for the production of Galvectra, a life-saving drug upon which countless people depend.
Is it not also indispensable for the cultural and religious rights of the Iraqi people?
Your Excellencies, it is indispensable for the cultural and religious rights of the Iraqi people, and we wish to emphasize that we do not argue that one human right should prevail over the other, as we have come here to advocate for the fullest realization of each of those human rights, not just the right to culture and religion, but also to the right to health. As Your
So in
Excellencies,
practical terms, how do we harmonize those competing rights?
excuse me, Your
In
Excellencies.
practical terms, how do we harmonize the competing rights?
Your Excellency, could you please rephrase your question? I have managed not to hear it.
How should we balance the rights to life and rights to health with rights to religious practice and cultural practices?
Your Excellency, in this respect, we would primarily refer this court to Article 18, Paragraph 3 of the International Covenant on Civil and Political Rights, which does allow for limitations that are necessary for the protection of public health and for the protection of the fundamental rights of others. Now, Your Excellencies, it is our submission that under that provision, the production of Galvectra, which provides an effective answer for one of the leading causes of premature mortality, is a justifiable ground for the protection of public health. Further, Your Excellencies, we also note that under the principle of necessity, ROCAB must show that the hunting had a proportionate impact on the Arakan people's human rights, and also that it was the least restrictive measure available. And in this case, Your Excellencies, we are going to formulate 2 points before this court. Firstly, with response to the first agent of the applicant's claim concerning the availability of alternative measures. Indeed, Your Excellencies, we do concede that there are other diabetes drugs currently available on the market. However, it is our submission that even those drugs cannot effectively combat diabetes. Your Excellencies, even those drugs do not effectively cure or prevent diabetes, as they merely treat the symptoms of the disease and not the cause itself. Whereas, Your Excellencies, it is indicated in paragraph 41 of the compromise that Galvectra has actual curative properties, which in our submission would render it a groundbreaking medication unequaled by any alternatives. And second, Your Excellencies, we would also point this court to the report created by the WHO to its model list of essential medicines, according to which, and I quote, "Lack of access to affordable insulin is a global problem, as more than half of the people who need insulin are unable to afford or access it."
So, Agent, your argument in part, it seems to me then, is suggesting that the government of Raqab is in some manner respecting the right to health by allowing the yak hunt to continue. Does that therefore then not essentially make Dorta an agent of the government of Raqab? In other words, it's Dorta that's acting in a manner that fulfills what you're suggesting is a fulfillment of the right to health. Does that therefore not somehow directly make their activities your activities and your responsibility?
Certainly not, Your Excellency, and in this respect we fully adopt the arguments put forward by my co-agent. And in this respect, our argument is that Dorta's conduct cannot be attributed to Raqab, as its nature is fully commercial, whereas we do concede that the purpose served by this conduct can be considered for the benefits of the public, which is the protection of public health. Now, Your Excellencies, therefore it is our submission that a fair balance has been struck between the human rights of the Orocan people and the medical advancements proposed by Go-Bactra, the life-saving medication. Therefore, we request this court to recognize that no violation of the Orocans' human rights have occurred. Turning to our last submission, Your Excellencies, I will argue that DROCOB is not obliged to share the benefits arising from the drug Go-Bactra for two reasons. Firstly, it is our submission that the Nagoya Protocol upon which the applicant relied does not apply to the present case. Secondly, and in any case, I am going to show this court that the drug Go-Bactra is an invention that is independent from the Orocan people's traditional knowledge, and therefore no appropriation has occurred for which benefit sharing might be claimed. Your Excellencies, with respect to our first argument, the applicant has put forward the argument that there is an ongoing utilization of the Orocan people's traditional knowledge, and therefore applying the Nagoya Protocol to the present case would not violate the principle of non-retroactivity as enshrined in Article 28 of the Vienna Convention on the Law of Treaties. However, Your Excellencies, in this respect, we would refer this court to Article 2 of the Nagoya Protocol, which specifically defines utilization. And Your Excellencies, in Article 2, utilization refers exclusively to research and development activities, and not to commercial distribution or production. Therefore, Your Excellencies, considering the fact that...
But couldn't the Nagoya Protocol be reasonably interpreted to relate to commercial activity and production if it relates to research activities that are specified in the protocol? Wouldn't that be consistent with the object and purpose of that treaty?
Your Excellencies, indeed, an argument could be formulated that utilization may refer to commercial purposes as well. However, Your Excellencies, what we put forward here is that applying such an extensive interpretation of what could qualify as an ongoing utilization could have unforeseeable consequences. As Your Excellencies, it could entail the claiming of benefit sharing for traditional knowledge that has been accessed hundreds or even thousands of years ago, as one could think of, for example, coffee, which was discovered by the Oromo people of Ethiopia, or for example, as a more recent example, we could refer this court to aspirin, which was extracted from the bark of the willow tree, which by then has already been utilized by indigenous peoples for medical purposes. Therefore, Your Excellencies, it is our submission that, and we urge this court not to interpret.
Aren't those situations quite different? In this case, it's certainly within a much shorter period of time, and in fact, your government had knowledge that there were concerns from Iraq quite early with the issuing of the patent. Difficult, isn't it, to make an analogy that refers back to historic events when the law has changed so significantly in the past decade?
Your Excellencies, indeed, we were aware of the objections formulated by Iraq even in the early 2000s. However, Your Excellencies, it is precisely our submission that due to the fact that at that time no international obligation was incumbent upon ROCOB, no action could have been required from the respondent side. However, Your Excellencies, even assuming that the Nagoya Protocol applies, it would not be fatal to respondent's case, as it is our submission that Go-Bactra is not a manifestation of the Orocan people's traditional knowledge, but in fact, the end product of 7 years of relentless research conducted by Dr. Jessup.
Is it not the case, though, that Dr. Bello's research was actually done in Iraq?
Certainly, Your Excellency, it was done in Iraq.
And is it conceivable that Dr. Bello could have discovered this without that time spent in Iraq with the Iraqi people?
Your Excellency, indeed, we can put forward that but for the Dr. Jessup would not have been able to create Go-Bactra without spending that year in Iraq. However, Your Excellencies, the main point we wish to emphasize here is that Go-Bactra treats diabetes, whereas the applicant has only utilized the yak gallbladder and the tyrannostotic as a promoter of well-being and as an aid in recovering from illness, as stated in paragraph 16 of the
And why is that not sufficient?
Your Excellencies, it is not sufficient because even though we do not require from any scientific certainty from the traditional knowledge holders, what we put forward here is that a clear distinction must be made between having the actual knowledge of certain health benefits and being the accidental beneficiaries of those health benefits, and it is the latter, Your Excellencies, that we put forward is at hand. Therefore, Your Excellencies, we respectfully request this court to recognize that Go Vector is an invention independent from oral and traditional knowledge, and the applicant has no right to claim the sharing of the
But
benefit.
with your argument, is it not going to be the case then that there'll be almost no circumstances where you will be able to find, in fact, that traditional knowledge has been developed? Because in the circumstances where traditional knowledge arises, the paradigm, I think, would suggest that it's not often going to be a situation where there will be that sort of direct knowledge of the potential future medicinal benefits.
Your Excellency and Mr. President,
Yes, please proceed. Quickly, please.
Thank you, certainly. Your Excellencies, we submit that even this restricted interpretation of the Nagoya Protocol does entail a number of cases in which traditional knowledge has been utilized. For example, we could refer this court to the Hugh case with some people, the neem tree, or the turmeric powder cases. Therefore, Your Excellencies, it is our submission that even this interpretation of the Nagoya Protocol should suffice before this court. Your Excellencies, if there are no further questions, I thank you for your kind attention and may it please the court.
Thank you, Agent. Agent for applicants, rebuttal.
Mr. President, Your Excellencies, respondent rises to surrebut on 3 points. First, with respect to due diligence, the respondent accepts that it was under an obligation to conduct a preliminary assessment with respect to the activities regarding yak harvesting, but relies on the information and reports collected by DORTA at paragraph 33 of the compromis. That is inconsistent with the deep skepticism this court demonstrated of self-serving statements at paragraph 76 of its Nicaragua opinion, inconsistent with the case the respondent relies on, the genocide opinion, when it considered that independent reports are far more valuable than those that are self-serving, and inconsistent with the objective standard and objective analysis this court identified at paragraphs 165 and 166 of its Pulp Mills decision when it considered the evaluation of export reports. Second, with respect to the disadvantage of the species point for the Convention on Biological Species, the respondent bears the burden of proof to show that its activities did not disadvantage of the species. But as paragraph 1 indicates, there was a 750,000 stable population of yak for decades prior to Rakab's hunting, and after Rakab started hunting, as indicated at paragraphs 27 and 36 of the compromis, there was a 10% decline in 2 years, precisely because of the manner of Rakabi hunting that had a disproportionate impact on young and female yaks. The respondent's submission was that there are no concrete numbers, but all of these are concrete numbers that indicate it cannot fulfill its burden of proof. Finally, and third, the respondent submits that there is no extraterritorial jurisdiction for the Twin Covenants and relies on the Bankovich decision to do so. However, as the court noted in that opinion at paragraph 65 and 67, it explicitly considered that extraterritorial effects could generate jurisdiction. That is a principle that dates to the 1985 Human Rights Committee's determination in the Guy v. France case, when it considered that the extraterritorial effects related to pension benefits could create jurisdiction. Thank you, and may it please the court.
Thank you, Agent. Agent for respondent. Sir, rebuttal.
Thank you, Mr. President. Your Excellencies, 3 points were raised by the applicant, and we are going to address them respectively. Firstly, the applicant claimed that our preliminary assessment, as evidenced by paragraph 33 of the compromis, should not be deemed sufficient in this court's jurisprudence. However, Your Excellencies, we would emphasize that under the current standings of international law, even the content of an environmental impact assessment is not defined in international law, but rather in the domestic legal system of states, as this is evidenced, for example, by this court's jurisprudence in the Pulp Mills decision and in the San Juan River cases. Therefore, Your Excellencies, it is our submission that, a contrario, a preliminary assessment's content is also set by the domestic legislation of the state. Secondly, Your Excellencies, applicant also argued that our hunting operates to the disadvantage of the yak. However, Your Excellencies, we would like to emphasize that the population of migratory species is extremely vulnerable and can be subjected to changes in their population from many natural and non-natural factors, for example, major development works, parasites, or diseases, and therefore, Your Excellencies, it is our submission that the applicant cannot substantiate that but for it was our conduct that caused the disadvantage and the decrease in the yak population. And lastly, Your Excellencies, the applicant also pointed to the paragraphs in the Benkovic case according to which extraterritorial jurisdiction can be established when acts produce effects outside state's territory. And Your Excellencies, indeed, this has been recognized in many cases, for example, in serving the United Kingdom. However, Your Excellencies, it is still a sine qua non condition that jurisdictional link must exist between the individual victim of those human rights violations and the perpetrator state, which, Your Excellencies, does not exist in the present case, and therefore, Your Excellencies, this concludes the respondent's rebuttal. I thank you for your kind attention.
Thank you, Agent. And thanks to agents for both the applicant and agents for the respondent for those submissions. The court will now go and deliberate.
The Honorable Court is now adjourned. Counsel and spectators will please remain in the room while the judges leave to deliberate.
Please be seated. Wow, what a great round of arguments. Congratulations to both teams. Well, the court is duly deliberated, and we have a split decision on best oralist. That just shows how close the contest was and how good each of the advocates was. Before announcing the best oralist, I do want to recognize each one of you for superb arguments. So, like I said, it was a split decision, 2-1. The best oralist is Gabor Batso. We'll refrain from saying who the runner-up is or was to keep each of you guessing, but it could have been any one of the other three, honestly. And so now, to announce the winning team of the competition, the winning team of the 2019 championship round of the Philip C. Jessup Moot Court competition is, or are, could be, no, definitely are, the agents for the respondent. There'll certainly be time for more celebration But before we adjourn, I want to just give my fellow judges a couple minutes to say some words. Judge Loewenstein.
Well, first of all, congratulations to both teams. You both did an absolutely superlative job. I kept on thinking to myself as I was listening to your advocacy, I'm very glad that the cases I work on are not nearly as complex as this case. Each side handled the issues with extreme dexterity, with phenomenal oral advocacy skills, and you both should feel incredibly proud.
Thank you. And now, Judge Adsett.
This was genuinely an exceptionally capable, talented pair of teams that we had before us today. And if there was ever any doubt that the future of the world is in good hands, I think we have proof of that before us. Your ability to think so quickly on your feet and your ability to respond to difficult questions, it just exceeds, I think, any expectations that anybody would have. So again, congratulations to both of you and to everybody who I know has put in countless hours of work and left your family and friends behind in order to be here. Very, very well done.
And finally, I just want to congratulate all those who have participated in these final rounds of the competition. Just being here is an accomplishment, and the amount of work that each of you put into this is really commendable. And our finalists have been really, really superb. I was a little bit intimidated by you, I must say, at times. But I'm sure you felt the same from us, or maybe more. So that evened it out. No, it's inspiring to hear from you, to hear these arguments that are really done at the highest level of advocacy, and I mean that, even taking into account professional advocates, lawyers who are out there. You know, and I want to just say that what you've demonstrated is a faith in the institution of international law and in the art of advocacy in international law. And what you've demonstrated is a capability in that art and in the institution. And so I would just ask you, as you go forward in your lives and your professions, that you use those tremendous talents that you have to do good, because ultimately that's what we're trying to do. So thank all of you. Thank you.
Good afternoon. Good afternoon. What an incredible round. What an incredible round that was. I'm Bill Berkwhite. I'm the chairman of the International Law Students Association. And on behalf of ILSA, congratulations to our two final round teams. What a truly extraordinary show you have just given us. Congratulations also to all of the competitors in this year's Jessup. This was by far the most talented and exciting year of the Jessup competition I have ever seen. Of course, the reason I am here is to announce the topic for the 2020 Jessup. But before I do that, I have to make a few remarks and thank yous. I want to start by thanking Leslie Ben, Tessa Walker, and the ILSA Executive Office. The job Leslie and her team do every year is tremendous, and this competition couldn't happen without you. Thank you. I also want to thank White & Case and its chairman, Hugh, who makes this competition possible with the firm's incredible generosity and, most importantly, their heartfelt passion and presence at the Jessup. Thank you, White & Case. But as many of you know, this is the 60th anniversary of the Jessup, and this year we have embarked on a new era, working in partnership with White & Case to expand the pool of sponsors and those who help make the Jessup possible, with the goal of ensuring that this competition has as bright and long a future as we have had a history. And so I want to thank a couple of new firms that have stepped up to join White & Case in sponsoring the Jessup, particularly King & Spalding, Baker & McKenzie, and Curtis Millay, who have really stepped up this year and joined as part of a great group of sponsors. We thank you for joining us. And of course, the chairman's job, in part, is to fundraise, and I've been doing a lot of asking over the last year. And I want to recognize the members of the new All Rise Society, 23 people this year who've made a long-term personal pledge to the Jessup to help make sure we have a very bright future. To the All Rise Society, thank you. And if you want to join the All Rise Society, it's not too late. Come see me or Leslie anytime. And also thank you to all the individuals who have given as part of our 60 for 60 campaign and otherwise to be part of the Jessup family. We're grateful to you, and you can still do that online. So with that said, I want to note that this is the 20th year that I have been involved in the Jessup. 20 years ago, I came up before a bunch of judges and said, "Your Excellencies, my name is Bill Berkwhite, and I represent the applicant, the state of Eötvös, in the matter before the court today." Now, of course, I didn't get to argue that at the international rounds, because unlike all of you, I didn't get here, at least not my first year. But I wanted to say that, that was a moment that I was truly hooked on the Jessup and hooked on international law. It was the 40th anniversary of the Jessup. It was also the 40th anniversary of the Universal Declaration on Human Rights. It was a moment where the future of international law seemed so bright. The International Criminal Court's Rome Statute was being negotiated. Pinochet was facing the prospect of trial in the United Kingdom. The rise of investment law and international dispute settlement opened up new opportunities for international lawyers to have jobs that paid and did international law. The United Nations Security Council seemed to be able to actually work to get the job done, and yaks were not endangered. We could all imagine a world where international law was working, where we might find a world free of genocide, and a world in which disputes, economic and political, were settled through the rule of law, not through trade wars or hot wars. Now, at that moment, I was excited to embark on a career in international law because I felt like it could work. Jump ahead 20 years, we find ourselves at the 60th anniversary of the Jessup, the 60th anniversary of the Universal Declaration on Human Rights. But the state of international law seems somewhat bleaker. Political leaders near and far are ignoring the rules and institutions that international lawyers before us have invested so much in to build. Populist and nationalist movements around the world are leading to a backlash against international law and the institutions of the global order. Countries are withdrawing from the very institutions they were joining 20 years ago, be it ICSID or the ICC. Yet global challenges from climate change to nuclear proliferation abound and perhaps seem worse. Institutions are withering as countries fail to invest in them or at times actively undermine them. And yaks are an endangered species. It might seem that there are dark clouds on the horizon, but for any of you who were outside today and saw the cherry blossoms in Washington, we know that rebirth is possible even in moments of challenge. 20 years ago, international law seemed to me a promising endeavor, but today it is an absolutely critical endeavor. The international institutions we know may be somewhat fragile. But this week we have seen that just like the cherry blossoms that are reborn every year, the tools of international law are reborn in Jessup courtrooms around the world every year. Those tools give all of us and all of you the ability to push back, to persevere, to strengthen institutions, to uphold rights, to ensure obligations, and to ensure that international law and the rule of law can keep the peace. This week has shown that you have the tools and the skills to do so. 60 years ago, the first Jessup final round occurred. Actually, it was the only round that year. Some things do change. But it was that same year that Eleanor Roosevelt presented the Universal Declaration of Human Rights for consideration by the UN General Assembly. And in that same year, as she presented it, she noted that people who continue to be denied the respect to which they are entitled as human beings will not acquiesce forever in such denial. The Charter of the United Nations is a guiding beacon along the way to the achievement of human rights and fundamental freedoms throughout the world. The immediate test is not only the extent that human rights and fundamental freedoms have been achieved, but the direction in which the world is moving. Over the last 60 years, the world has moved far in the right direction. But it is now up to you to determine what the direction from here will be, to chart the course for international law for the 20 years ahead. So when we reconvene for the 80th anniversary of the Jessup, the 80th anniversary of the Universal Declaration, we will find an international legal order stronger than the one we inherit today. So it's time for you to go home and do that work over the next 20 years. You know you have the tools to do it, and the world so urgently needs you to do so. Now what you really want, no applause, what you really want, the Jessup Problem for 2020. The 2020 Jessup will address multi-fora international litigation, accountability of heads of state for war crimes, killer robots, and a wall.
It's been a great week, and I owe it all to a number of people who have been here working with me and for the Jessup. I need to recognize and thank some of them while your judges continue to deliberate. First, the staff of the Executive Office, Tessa Walker, Chris Monet, and Laura El-Jebaji. I'm so fortunate to work with the three of them. They are absolutely amazing, and I'm so grateful for all of the hard work that they've put in this week. I want to echo Bill's recognition and thanks to our global partner, the law firm of White & Case. The firm enables us to do so much through its sponsorship of ILSA and the Jessup, both here in Washington at the international rounds and also in over a dozen countries around the world. I would like to personally thank Elizabeth Black, the senior manager of global citizenship at the firm, who oversees the Jessup activities around the world and plays a critical role here at the international rounds in our judges' room every year. I also want to I'd also like to thank and recognize Jackie McLennan and Joe Weiss, who are also here from White & Case today. There are a group of people who volunteer with us every year whose work behind the scenes makes the competition an enormous success. First is our oral rounds judge coordinator, Rusty Delferez. Thank you so much. Next is our memorial judge coordinator, Maria Iseva, who we've missed here in person this week, but thank her in absentia. Thank you to our scoring coordinator, Michael Pyle, who's here all the way from Bhutan with his amazing wife, Judy, and his two adorable children, Tucker and Lucy. We have a core group of interns and volunteers who've made everything from our bailiff's room to our merchandise table to our extra backup judges fantastic and make sure everything was covered. I'm going to read them off in alphabetical order, including what country they're here from. Caroline von Borstel from Brazil, Lucas Graf Campus from Brazil, Maxim Holub from Belarus, Rafaela Horman from Brazil, Richard Lee from China and the US, Ksenia Matveeva from Belarus, Maria Milashevskaya from Belarus, Eugene Mintsevich from Belarus, Victoria Mitskevich from Belarus, Scott Mullings from Jamaica, Catalina Patarroyo from Colombia, Brittany Shales from Canada, Laura Dovale from Brazil, Shane Young from the United States, and Jamal Jusupova from Kazakhstan. Thank you all so much for all of the work you've put in this week. I'd like to thank our photographer, Anastasia Zukova from Russia. I would also like to thank and recognize the photographer, videographer, social media and events teams from White & Case, Ennio Rizzi, Everton McLean, Aaron Knoll, Katarina Berry, Karine Aquafreda, and Chris Gabor. Thank you all. I have to thank the authors of the 2019 Jessup Compromis, Michael Pyle, Hannah Zhao, and Douglas Pivnichny. It's been a privilege for our executive office to work with the three of you, and we're extraordinarily grateful. I want to recognize and thank ILSA's board members, who are individuals who volunteer their time and effort to work behind the scenes to make all of this possible. I'd like to recognize the friends of the Jessup. There are too many of them to name individually, but the coaches, team advisors, friends, and colleagues who have helped prepare teams to be here and help support them. Thank you all. Thank you to the sponsors and supporters of the Jessup teams that have competed here in Washington. The sponsors and supporters range from governments and governmental agencies of many of the countries competing, to your universities, law firms, other organizations, and even your friends and neighbors. All of their contributions have made an enormous difference to this year's international rounds, making them one of the most competitive and diverse in history. A special thank you to all of the national administrators who organized and ran competitions around the world, many of whom are here today as well. And of course, I have to thank the hundreds and hundreds of judges who have volunteered their time and expertise to judge oral rounds here and in national competitions around the world. Thank you. I now have a few awards to present. Again, your judges are continuing to deliberate. First is the Pamela Young Award. This award recognizes friends of the Jessup that have been of particular assistance to the executive office this year. These individuals, like Pam Young, exemplify the passion and dedication that are present in all of our friends of the Jessup. With respect to our first recipient, I don't know if the students and coaches and judges understand how much work goes into creating these international rounds. There were 143 teams this year, which means 286 preliminary round matches. And that means that there were 858 judges' chairs to be filled and judges' robes to be worn. Every single panel of 3 judges that you faced is lovingly crafted to be balanced for gender, national origin, the background of the judges, and the style and frequency of the questioning. During the week, he's the first person in the judges' room preparing for inevitable emergencies and last-minute switches. The first recipient of the Pam Young Award today is the man that has made that happen for more than a decade. This is the second Pam Young Award he has received, with the first being in 2008 from one of my predecessor executive directors. This is also his 20th year of involvement with the Jessup competition, and I can think of no more fitting anniversary on which to recognize him. Rusty Dalfrez, please come and accept this award. Every year, our second recipient of the Pam Young Award is one of the cornerstones of the Friends of the Jessup. He's an institution in the judges' room, on the benches, and flitting through the hallways of certain national competitions and the international rounds, camera in tow, chronicling our unique community. He oversees the social media presence of the Jessup in Brazil. He cares deeply about establishing a legacy of support for the Jessup competition, and can easily be called one of the godfathers of the modern Jessup in Brazil. He has traveled the world over the years, spreading the Jessup message to countries all over the world, and he has done that without any institutional support. He has dedicated himself to law students and has given generously to support Jessup students directly and to support ILSA as an institution. I would like Vasco de Jesus Rodriguez to please come up and accept the Pamela Young Award. Vasco, I'm going to ask you to come back up here for a moment, if you don't mind. The third Pamela Young recipient is not a person, but a Jessup community. I just mentioned how instrumental Vasco has been to the Jessup community in Brazil. The Jessup in Brazil is something special. It is a large and vibrant community who routinely sends top teams here to DC. And as the team from Leiden University knows, their graduates sometimes go on to be coaches of teams all over the world. Over the past several years, students and attorneys and professors from Brazil have formed an indispensable infrastructure, contributing judges, bailiffs, and other workers and volunteers to the international rounds. They've basically taken over the bailiffing room and the coordination of the bailiffs, a Herculean task in its own right here in Washington. And two of them are even here bailiffing the championship round. Starting in 2015 with Andre Freio and continuing over the last 5 years, there have been more than 30 young Brazilian law students who have paid their own way, staying here at the hotel with us, and have worked round the clock in indispensable roles on our administrative team. I would like to ask Rafaela Horman and Lucas Graf Campos to please come up here and join Vasco for a moment. For all of the above reasons, for the first time in the history of the Jessup competition, this Pamela Young Award is going not to an individual, but to an institution. I am honored to present the Pam Young Award to Jessup, Brazil.
Thank you.
All right, next is the Stephen Schneebaum Outstanding National Administrator Awards. This award is named in honor of Stephen M. Schneebaum, who is the founding chair of ILSA's Board of Directors. Mr. Schneebaum has filled a critical role in the organization and administration of the Jessup competition for decades. This award is presented to national administrators for outstanding service and dedication to the Jessup competition. There are 3 recipients of this award this year. Historically, this award has gone to administrators of huge competitions, and we see the results of their labors when we have 4 or 5 or even 6 teams coming out of their enormous national rounds. But our first recipient is a little different. She comes from a 2-team jurisdiction and administered the first national round there since 2016. However, the impression of what she created this year was much larger than that. She brought in new sponsors and supporters, including one of our favorites, a chocolate company, and created an identity for the competition with a piñata that we've had here with us all week. I received several emails directly from the students participating, expressing how much she did to make the national rounds a success. The Guatemalan national rounds have had an impact and an influence that far outweighs the actual size of those rounds. That is why the first Stephen Schneebaum Award goes to Claudia Caceres from Guatemala. Most of us in this room understand how much it takes to start the Jessup in a country for the first time, or to grow the Jessup in a country that doesn't have a long mooting culture. Our second recipient took over the administration of the Jessup in his country in 2017 and built the national round, which debuted only the year before, into a record-setting 7 law schools this year. There is no region in the world where the Jessup is growing and developing as successfully as in the Middle East and North Africa. And it's because of the commitment of this person and his law firm to the Jessup that there is now a meaningful national competition in Egypt, where just 4 years ago the Jessup did not even exist. And that is why I am pleased to present this second Outstanding National Administrator Award to Adam El-Shelakani of Egypt. Our final recipient of this award was responsible for the resumption of a national round in 2018 after 12 years without one. He worked tirelessly to ensure that the 3 law schools who participated had access to resources, assistance, and support to build their Jessup capacity. As you know, I attend several national and regional rounds every year. This year, I was particularly struck by the quality of the organization and the community that has been created and sustained in Uzbekistan under the leadership of its national administrator. It was one of the most memorable places I have ever visited, and the Jessup has been built and sustained in Uzbekistan as a direct result of the dedication and hard work of the next recipient of the Stephen Schneebaum Award. It is my privilege to be able to present this award to Salim Yusupov.